all, the court is now in session. Please be seated.
For those of you that weren't here for the first cases, we've got a different panel. We're tag teaming this morning, so let me introduce this panel. Judge Armstrong from Shelby County, Judge Guzman from Davidson County, and I'm Judge Golden from Shelby County. All right. The only rule I would suggest, and y'all are veterans here, is that the appellant gets rebuttal if you would like rebuttal. You can ask for up to 5 minutes of rebuttal. We'll set aside that time for you. Of course, the appellee does not get rebuttal. All right, you may call the case.
Clarence Mitchell et al. Versus Rushmore Loan Management Services, LLC et al.
Good morning. I'm Webb Brewer from the Shelby County Bar, and I represent the appellants, Clarence and Leslie Mitchell, in this matter. This case began
Mr. Brewer, would you like to reserve any rebuttal time?
Oh, I'm sorry. Yes, I would like to reserve 5 minutes.
5 minutes? All right. You may proceed.
Okay, this case began in the Chancery Court of Shelby County on a petition to enjoin a foreclosure sale and for damages against a loan servicer, Select Portfolio Services, and the trust, U.S. Bank Trust, which was trustee for a securitized trust, and a subsequent servicer called Rushmore. The allegations in the complaint were for breach of contract and breach of the covenant of good faith and fair dealing. The court granted injunctive relief and stopped the foreclosure sale. A motion to dismiss was filed. The trustee, U.S. Bank, was dismissed with an opportunity to refile, but it was not refiled. The case proceeded on against the two servicers. At some point, a motion for summary judgment was filed based upon the theory that there was no privity of contract between the plaintiffs, the Mitchells, and the loan servicers. That motion was denied, and the defendant servicers sought to get an interlocutory appeal from this court, which was denied. They then filed a renewed motion for summary judgment arguing the privity theory, as well as saying that there was no breach of contract alleged, and therefore the covenant could not lie, a breach of covenant of good faith and fair dealing. We had a hearing, and the court granted motion for summary judgment and stated, I'd like to quote briefly from the court's order if I could, a claim based on the implied covenant of good faith and fair dealing is not a standalone claim, rather it is part of a breach of a contract claim. Moreover, in the hearing, the plaintiff's counsel admitted that there was not a breach of any specific contract term, and that the plaintiffs were focusing only on the claim of breach of the covenant of good faith and fair dealing without a specific contract term. Since there has been established...
Is that correct?
I'm sorry?
Is that correct?
Yes,
It's correct that you admitted that there was not a breach of any specific contract term?
that's correct.
All right.
And I think that kind of gets us to the heart of that issue, which we submit that that's just plain wrong.
Counsel, can we take one step back from there? I'm trying to understand how you can have a breach of contract claim against the loan servicers here if they're not a party to the contract. If there's no privity here between the loan servicer and the Mitchells, how can the Mitchells bring a breach of contract claim against the loan servicers who they don't have a contract with?
Well, there's no Tennessee case on that point directly in the context of mortgage servicer. The general rule is that if it's a disclosed principal, that, you know, the principal must be party to the case. Now, that's never been held by a Tennessee court in the mortgage context, and the trial judge denied the summary judgment based on that theory. The only case, the only real authority on that, there was a U.S. District Court case called O'Connell versus Soteris, which Judge Lippman in the District Court in Memphis ruled that there was no privity and dismissed the case against the servicer.
Counsel, would you agree as a general matter that a contract claim, to have a valid contract, breach of contract claim, I need to have privity in order to successfully sue on a breach of contract claim? What would make this different? And why should we look at a loan servicer any differently than what any other breach of contract claim?
Well, I made some fairly lengthy argument about that in the brief. In the mortgage context, where in the contemporary mortgage situation where there's generally a lender and then an assignment to a trust, and sometimes multiple assignments, and the only entity that the consumer, the borrower, deals with generally is the servicer. And in fact, not this case, but I've been involved in a case recently where even during litigation, the title to the mortgage changed hands multiple times. So I've argued that this is a kind of a unique situation where the entity who's the principal literally has had no contact very often with the borrower. And in some instances, the borrower may not even know who is the title owner to the property. So we think that should be an exception to the general rule.
How does that change the fact of whether or not there's privity? How does that change the fact of whether or not there's privity of contract?
Well, it doesn't. I mean, there is no contract between, in this case, the borrowers and SPS. Of course, there are multiple transitions, and I guess the bank, the owner, is an assignee, but there's often, again, the privity is pretty extenuated in these kinds of transactions.
Well, let me ask you, here where you concede that the appellants have no right to a modification, what do you say is a wrong committed by the loan servicer here, where it simply denied their application, which they had a right to do because your client had no right to a modification?
And I would agree with that premise, that there's absolutely no right, and the Mitchells don't assert that they had a right to a loan modification. They didn't have a right even to be offered to apply for a loan modification. What we would argue, though, under the covenant is that as servicer, if the entity undertakes to well, it's part of their they're servicing the loan in the sense that they're accepting payments and things of that sort. If in the course of that they begin to counsel or advise people of their right to seek a modification, then we argue that the covenant would extend to require them to provide accurate information, a reasonable standard of that. In this case, what has been alleged is when they first got into the loan modification system, they were a couple of months behind on their mortgage payments, sought to get some relief, hoped to get their payments lowered and maybe extended to the end. They engaged in a long period of making applications, having them rejected, making other applications, and they couldn't make payments during that period or without paying the full arrearage, and what turned in from a small problem turned into a large problem. I would cite to the
But that was not due to the fault of the loan servicer. The contractor, the deed of trust provides that they don't have to accept a partial payment. You have to make the full amount and catch up the arrearage. In addition, in the notice letters to the appellant, they were advised that they didn't qualify for modification.
And they were encouraged in they were in form letters, and they were encouraged that you can reapply if you don't agree. And on a couple of occasions, they were offered some kind of loss mitigation packet, but it wasn't the kind of modification that they sought. So I want to emphasize, we're not arguing that there was any entitlement or right to get the modification. But our contention is, had there been adequate or accurate information offered in the first instance, they might have sought another recourse and instead dug themselves into a very deep hole.
You'll have your rebuttal time. Thank you.
Thank you.
Thank you. Good morning, and may it please the court. Patty Whitehead, and I'm here representing the Appellee's Select Portfolio Servicing, Inc. As the appellant stated in this case, there really aren't undisputed facts here. The Mitchells made their last payment on this loan in October 2014. It's been admitted there is no right to a loan modification in this case. It's been admitted that SPS, Select Portfolio Servicing, isn't even a party to the deed of trust in this case. The record shows that the Mitchells applied for loss mitigation 5 times over the period of many years. With each application, SPS acted in good faith, they reviewed it, and they sent a denial letter or repayment options. Repayment options were sent twice in this case. But as appellant's counsel stated, it wasn't the loan modification they wanted. Despite all these concessions, appellants still claim a grievance against SPS. And they are asking this court to impose additional duties on loan servicers of mortgages. This is not an exceptional set of facts. It's not an unforeseen set of facts. This is a case where borrowers defaulted on their mortgage and weren't accepted for loan modifications. They did that 5 times. And when foreclosure proceedings started after the 5th application, in 2017, this lawsuit was filed to halt the foreclosure. Now we're here in 2023, still arguing this case with no payment being made since 2014. And I would like to start with the privity argument. While the trial court declined to render summary judgment on this basis, I would ask this court to affirm the court's order on the basis that there was no privity between Select Portfolio Servicing and the Mitchells. A breach of contract claim is based on a contract actually being in existence. It's been the law of Tennessee for many, many years that privity of contract is an essential element to a breach of contract claim. SPS was not a signatory to the deed of trust. They weren't an assignee. They were a servicer of U.S. Bank. And I think of great importance here is
Counsel,
that,
is U.S.
yes.
Bank a disclosed principal in this case?
Yes, U.S. Bank is the disclosed principal here. Anytime a loan is serviced, the servicers send out notice of that. The borrowers knew who the lender was. That's obvious from this case, the fact that they sued the lender. They sued U.S. Bank. There were no counts made against it. And in fact, after privity of contract was already argued, Chancellor Evans gave the Mitchells a chance to amend their complaint to state a claim directly against U.S. Bank as the lender here. They declined to do so, and U.S. Bank was dismissed.
Was there any argument raised below to challenge the notion or the conclusion that U.S. Bank is a disclosed principal? Are there any facts that were presented that raised issue with that? Any argument that was raised that would challenge the underpinnings of a conclusion that U.S. Bank was a disclosed principal in this case?
The only arguments that were made is that we shouldn't apply the disclosed principal rule to this case because it's mortgage servicing.
So the argument is one of non-application of the rule rather than they're not a disclosed principal?
Yes. Yes. And while there's not any Tennessee state cases concerning the privity, the O'Connell-Soteris case out of the Western District of Tennessee directly addressed this and stated that any claims derived from a breach of contract from a loan servicer in a mortgage setting had to be dismissed because there is no privity here. This wasn't just the Western District that agreed with this. Federal cases in the District of Columbia, Georgia, and West Virginia all come to this same conclusion. And I believe it comes down to basic contract law. There must be privity of contract for a breach of contract claim to be sustained. It has been admitted that there is not here. And for that reason alone, this court and the trial court should have granted summary judgment as to SPS. Now, even if we found that, well, maybe there's privity, maybe there is an issue of agency in this case, which we don't believe there is. But if we did, the law in Tennessee is clear that you can't have a breach for violation of the covenant of good faith and fair dealing without a breach of specific terms of a contract. This is stated in Cadence Bank versus the Alpha Trust, which states, without a breach of contract, a party cannot sustain a claim for the breach of the implied covenant. Breach of covenant for good faith and fair dealing is not a standalone claim. It's implied in contracts, but it cannot extend beyond the terms and reasonable expectations of that contract, meaning we can't create additional duties for contracting parties here. Now, I do know that in the brief, appellants state that, well, it can be a breach of the covenant if one party purposely prevents performance of another here. And the argument is that they were not allowed to make payments after they had become in default. They were allowed to make payments. The Mitchells could have made payment so long as the payment was in full to cure the default.
So what about the contention in this case that they were advised not to make the payment? And isn't the assertion that part of this began with you shouldn't make the payment while you're going through this process of seeking loan modification?
Well, we would state and it's of record in the affidavit made by SPS that that is not what was stated. And the servicing notes reflect that. It was stated, we won't accept payment unless it's been made in full. The allegation that the Mitchells were told, don't make any payment, comes from an unsworn declaration of Ms. Mitchell, which we would advise is not proper for evidence under 56.06. It's made to the best of my knowledge. It is not signed under oath. It is not sworn to by a notary. So we would state that there is no evidence of that in the record. So based on this case, an appellant admitting there was no breach of any contractual provision, this is another basis that the trial court was correct. Without breach of a specific term of the contract, there is no claim for breach of the covenant. I would also state that if we were to impose the covenant of good faith in this manner, it would create additional duties to the parties. And appellant's counsel should be aware of this. He made this exact same argument in 2017 before this court in Jackson v. City Mortgage. The facts are very, very similar to what we have here. The borrowers had a previous loan modification. They came in default. Citi, who was the lender and servicer, in that case told them that they could only accept full payment. The appellants argued, well, you told us not to make payments. The foreclosure was postponed twice there, but a loan modification was never entered. And appellant's counsel argued that Citi was bound to exercise good faith in the loan modification process. Very similar facts to what is before this court. And this court found that Citibank was under no obligation to review the loan modification or postpone the foreclosures. And I would quote, this is what was stated about the Jackson case. Some contracts require the completion of action outside the literal terms to ensure fulfillment of contract when unforeseen circumstances arise. This is not one of them. The court also found that executing the terms of a contract cannot be bad faith. The deed of trust clearly states that the lender doesn't have to accept partial payments. They did not do so here. The deed of trust states that upon default, the loan can be accelerated and the property can be foreclosed. It does not mention any right of loan modification. It doesn't mention that it has to postpone the foreclosure in any way. And additionally, default on a mortgage is not unforeseen. It is contemplated within the terms of the contract. That is where we get the power of sale. It is where we get the foreclosure terms. It's where we won't accept partial payments. We need payment in full. SPS, even if it was in privity of contract, followed all of the contract terms. To add additional rights to loan modification and review of loan modification, and it must be done in this way or done to satisfy what the borrowers would like, is not in line with the law of Tennessee. And it would go against public policy, as the right to contract is sacred. Parties can contract as they wish. That is what is done here. And finally, I'd like to state, even if there is privity of contract, and even if this was a standalone claim for the implied breach of covenant of good faith and fair dealing, SPS acted in good faith. It was reasonable. All of the allegations set forth by the appellants in this case are disputed from the record. We've already discussed how the Mitchells alleged they were told not to make payments, but the record shows that that's not what they were told. They were told they had to make payment in full.
And that's by way of an affidavit from a representative of the service company?
Yes, Your Honor.
And that was allowed to be paid out over a year, I think, wasn't it?
Under the repayment terms that were offered, I believe in the fourth loan modification, that arrearage, it was going to be a new payment with the arrearage added on top to be repaid. but it was not added to the back end of the loan as the borrowers were hoping for. There was also a lot of talk about SPS didn't give the correct information to the Mitchells. They didn't tell them what they didn't apply for. But again, the record shows that this is not the case. In response to the second loan modification back in July of 2016, it specifically stated that they were denied for the home affordable mortgage program. It also said that they were denied for 4 or 5 other programs that SPS had reviewed. They simply didn't qualify for the program. Another allegation is that SPS service transferred the loan during the review. So foreclosure proceedings were instituted while loan modification was ongoing. Again, the record shows that the 5th and final loan modification was denied before the transfer and before the foreclosure that preceded this litigation. The record in this case simply does not support anything but affirmation of the trial court's grant of summary judgment here. The Tennessee law is clear that there must be privity of contract, which there is not here. And the law clearly states that a claim for breach of covenant of good faith and fair dealing is not a standalone claim, but must be based on a breaching a specific term of the contract. It's been admitted there is no breach of contract in this case, and this court must affirm the trial court's grant of summary judgment.
Let me ask you, the letter to the Mitchells didn't just say there's no mitigation option for you. It also specifically set out all of the programs for which that were not available to them. Is that right?
Yes, it specifically said that they were not, they reviewed them for the home affordable mortgage program, and they did not qualify. They have reviewed them for unemployment programs, did not qualify, and 3 or 4 others. So it was specifically stated what was reviewed.
Okay, thank you.
Any other questions? Thank you.
Thank you.
Mr. Brewer, you have your rebuttal.
Just a few points, Your Honor, if I may. I will resubmit and argue that the trial court made an error in its holding and then ruled based upon that and didn't consider any of the factual matters, whether there were any contested issues of fact that would make summary judgment inappropriate. I wanted to quote some language from the Cadence Bank versus Alpha Trust case on which the court relied in granting summary judgment. In this language says, the implied covenant of good faith and fair dealing is not limited to the specific contract terms, but is a method of effectuating the party's intent in unforeseen circumstances. So I think that the chancellor made an error because he said in his ruling, I think pretty clearly, that if there is not a breach of a specific term, then you can't travel under the covenant of good faith and fair dealing. And cut off inquiry at that point. Again, what we want to emphasize is, and I mentioned the Goot v. Metro Nashville case earlier. In that case, and it was complicated facts about benefits to former Metro employees, and the widows or survivors of deceased beneficiaries were not given any information. There was an election that they could make which would have been beneficial to them. That was not made to the spouses of employees. The court there held that under a duty of good faith, that it was incumbent upon the city to inform those spouses that it would be in their interest to make this election, and they didn't, at least the plaintiffs in the case, because they were not aware of it. We think that case is analogous to what we're arguing here because, again, they're not claiming they've got any right or entitlement to a loan modification of any particular kind or anything of that sort. But Mrs. Mitchell's affidavit, or declaration, I should say, stated clearly that in her first conversation with the representative of SPS, she was told that partial payments couldn't be accepted. That's not disputed. You'd have to pay the full amount to catch up or apply for loss mitigation, which is what they did. What we think is the fact issue here is that it appears from the records, they submitted voluminous records, which, you know, are arguably business records, but with, you know, they're not verbatim, they're not a witness testifying. She testified that she was led to believe, or was not told, that she could not get the kind of full-blown HAMP loan modification that they were seeking. Had they understood that they would not have spent literally a couple of years trying to get the loan modification, submitting application after application. So we do think that that's analogous to the Goode case.
Back to that first step again, the privity question. Is U.S. Bank a disclosed principal in this case?
I'm not sure that it is. There is a legal requirement that at some point, if there's a transfer in notice, in ownership, that it's in the Truth in Lending Act and an amendment, that notice had to be given by someone, and that's usually delegated to the servicers, but I'm not sure that...
Have you asserted that that notice wasn't provided here?
I'm not sure. I don't think that notice is in the record. I don't believe, but I'm not absolutely certain about that.
Did you raise any challenge to the notice having been provided? Is there anything below in any of the pleadings that you say the notice wasn't provided in this case?
No, because there's really not much remedy if it's not, and that was not pled as a cause of action. I don't think it was in the discussion. As I say, because the chancellor kind of short-circuited this inquiry, what our request would be that the case be remanded back for further findings of fact, further consideration of the evidence that was presented, which had not been done. It was kind of aborted because, you know, he said there was no breach of a specific contract term, so we must grant summary judgment. So we would argue for a remand.
Let me ask you, are the letters denying the application, are they in our record?
Yes, they are. And I would submit that they're basically, there's some variations, but they are basically form letters.
And in that form letter, does it also say that the Mitchells do not qualify for a HAMP modification?
In one of them, it says something like that, which I think probably, to be candid, I think to an insider, they might have understood that, but I'm not sure that a consumer would, or the Mitchells did not, is their testimony. And if I could, if you'd indulge me just one second, they have asserted that the affidavit or the declaration of Ms. Mitchell is not proper for consideration. It was sworn upon facts that are known to me, and it was a declaration under penalty of perjury. There was language at the bottom that said, upon the best of my knowledge, information, and belief. But at the outset of it, it says that this is based on facts known to me. I think it clearly complies with Rule 56.06. So I think that her testimony should not be excluded.
Thank you very much. Thank you for your argument. We will address this and get you an opinion as soon as possible. Thank you very much. Can I adjourn court until this afternoon, please?
All rise.